All I showed was proof that the truck was insured,
No,
registered.
all right, I'm not gonna deal with it. All right, let's set a trial date. Set a trial date.
I'm trying to get this dismissed. This is this is literally holding me back right now.
You get it dismissed on the date of trial. Date of trial.
The hearing starts with a simple disagreement over documentation. The defendant insists that he already showed proof that the truck was insured and registered, but the judge refuses to dismiss the matter and tells him that he can make that argument at trial. Instead of accepting that answer, the defendant immediately becomes frustrated, saying the case is holding him back. The judge remains firm, and within seconds, the tone shifts from a legal disagreement to a personal confrontation. At this point, the key issue is no longer just the paperwork. The real question is whether the defendant can control his frustration long enough to make his case. What would you have done in that situation? Accepted the trial date or continued pushing the judge for a dismissal?
Nice. No, I see clear as day why I'm not getting the same courtesy. Your name is Sean Perkins? Yeah, okay.
That's the last time I checked.
Yeah. Okay, I get it.
Mr. Gubin.
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking to me.
I was just gonna ask, did you want to go in a breakout room?
What is a breakout room? I showed all my proof. I showed all the proof. I showed the proof, Mr. Sean Perkins. What is it? Is it my, what is it? My complexion?
Have a good day,
it's my complexion, isn't it, buddy?
Have a good day,
Mr. Uneducated Judge.
Have a good day, Mr. Gubin. You keep on talking.
How are you even a judge?
The tension rises quickly. The defendant suggests that he is not receiving the same courtesy from the court, and then his frustration turns into direct attacks against the judge. The court attempts to end the argument, but the defendant keeps insisting that he already provided proof. Then comes the most serious accusation. He suggests that the way he is being treated has something to do with his complexion and calls the judge uneducated. That changes everything. A courtroom disagreement over documents has now become a confrontation over respect, fairness, and alleged discrimination. The judge warns him that he can be held in contempt, but the defendant continues.
I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
What a clown.
You done?
Anything else?
Are you
Anything
done?
else, pal?
All right. I'm gonna hold him in contempt. I'm gonna give him 30 days Wayne County Jail, all right?
The judge finally makes the consequence clear. The defendant is being held in contempt and is facing jail time. What makes this moment so important is how quickly the situation escalated. The original dispute was about whether the defendant had provided enough documentation. But once insults and accusations entered the conversation, the focus shifted completely toward courtroom conduct. The defendant still continues with his remarks, and the judge announces a sentence of 30 days in Wayne County Jail. This is a powerful reminder that even when someone believes the court is treating them unfairly, the way they respond can dramatically change the consequences they face. Was the defendant justified in being frustrated, or did his own behavior make the situation much worse?
Right, okay.
You have an absolute right to a hearing.
You will expect a huge lawsuit. I showed you every single proof of documentation that I needed to, and you refused to dismiss my stuff.
Have a great day.
Why is that?
Have a great day. We're not talking anymore, all right? We're done talking.
Yeah, that's what I thought.
30 days Wayne County Jail. City of Detroit, we're ready. City of Detroit versus Joshua Gubin. Number SP14114481. Strike that. SP14114448 counts 1 and counts 2. SP166967 counts 1 and counts 2. SP16696731. Appearance for the record, please.
Yes, good morning, Camilla Barkovic, P78254, appearing on behalf of Mr. Joshua Gubin, who is present.
Good morning, Mr. Gubin. State your name for the record, please.
Good morning, Joshua Gubin.
Today is the date and time set for a pre-trial. I do have an offer here, which is pleading responsible to.
The camera, no camera.
Hold on, Mr. Grant. Is pleading responsible to the amended count of limited access 1 to 5 for the speeding, and as charged, I'm thinking of the improper equipment,
That is correct, Judge.
and then other matters are to be dismissed. Is that correct?
That's accurate.
You want to take the deal, Mr. Gubin?
Yes, Your Honor.
Will you stipulate on behalf of your client to the basis of the ticket as an active factual basis for that responsible plea on your client's behalf?
Yes, Judge, I
Will you
will.
stipulate the probable cause for the dismissal of the other matter?
Yes, Your Honor.
All right, I'm gonna find your client responsible for the amended count of limited access 1 to 5 for the speeding based on that stipulation. And as charged to the improper equipment.
Thank you.
It'll be $125 for the limited access 1 to 5, and $120 for the speeding ticket. I'll waive the warrant fees.
Thank you, Judge.
The video then moves into another portion of the case involving Joshua Gubin. His attorney appears with him for a pretrial hearing, and the court presents a negotiated resolution involving speeding and improper equipment charges, with other matters being dismissed. Gubin agrees to the deal, and the judge formally finds him responsible for the amended speeding count and the improper equipment charge. The financial penalties are also explained, including $125 for one charge and $120 for speeding, while warrant fees are waived. At first, everything appears routine, but then the attorney raises a much bigger issue. The court is preparing to take Gubin into custody because of an earlier contempt matter. His attorney immediately asks the judge to reconsider. And now the real story begins.
And he'll pay any reinstatement fees, which I don't see here. Anything further? He's done. We're going to take him into custody.
Well, Judge, I wanted to ask that you respectfully reconsider your position. I reviewed the record of the hearing in question. I understand that my client's conduct may have been considered disruptive and disrespectful by the court. A lot of time has passed since that occurred. That's no justification. But I think it's important for you to know the circumstances under which his actions occurred. So unfortunately, my client was suffering from the flu extremely bad that day. He remained on Zoom for an extended period of time. I'll even attest, I have sat on Zoom for an extended period of time, and oftentimes it becomes extremely frustrating. Obviously, this court moves its docket. This court is very accommodating. But given his illness and given the circumstances, he was not a happy camper. Again, that is no excuse for his actions towards the court. You obviously don't know Mr. Gubin. You probably never will. I've known him for an extended period of time. He is not who this court may think he is. He has always been respectful, diligent in addressing all of his obligations. He's 27 years old. He does not have any significant or substantial criminal history. He's married. He has 2 minor children who are absolutely beautiful. His pride and joy. He owns and operates his own business in Wayne County, specifically a gas station. His wife doesn't work. He's the sole provider for his family. Judge, if you would consider not imposing a jail sentence at this time, and maybe imposing an alternate sanction, which the court has authority to do, such as a fine, or anything else that this court deems appropriate, such as community service, my client will gladly accept that. I do know that he wishes to make a statement directly to this court, and I'll allow him to do that at the present time if the court would permit.
Gubin's attorney acknowledges that his client's behavior was disruptive and disrespectful, but asks the judge to consider the circumstances behind it. According to the attorney, Gubin had been extremely sick with the flu and had remained on Zoom for an extended period. He argues that the situation became frustrating and that Gubin was not in the right state of mind that day. But the attorney does something important here. He does not claim that illness excuses the behavior. Instead, he asks the court to consider Gubin's larger circumstances. He tells the judge that Gubin is 27, married, has 2 young children, owns a gas station, and is the sole provider for his family. Rather than jail, the attorney suggests alternatives such as a fine or community service. This creates an important contrast. The court is focused on what happened inside the courtroom, while the defense is asking the judge to consider who this person is outside that single incident. Should a person's personal circumstances affect how a court responds to serious disrespect?
Let me say this. I appreciate your argument and your diligence on the behalf of your client. I went over and I reviewed I thought I exercised the utmost restraint in the the blatant disrespect that Mr. Gubin. And let's go back to your about the Zoom. And there's always an opportunity for an individual to come in person and sit in the court.
Sure.
So that's sort of like, the court looks at that as sort of like a benefit. You know, we allow people at work, we allow people at home who are sick. I didn't know he was sick until he mentioned something about being sick in the middle of, toward the end of what, but that's of no consequence of the court. I really don't care about him being sick. His obligation, he could have said, I'm sick and can we pass this on? But it was every attempt to the court tries to offer individuals an opportunity to show documentation, which the court doesn't have to do that.
I know.
If he didn't have proper documentation at the time to stop, the court doesn't have to take that extent in dismissing the case because it's bringing proper documentation now. It is the court's view of Mr. Gubin's actions is that Mr. Gubin was trying to deceive and perpetrate a fraud upon.
The judge listens, but clearly does not see the situation the same way. He explains that he reviewed the earlier hearing and believes he showed significant restraint despite what he describes as blatant disrespect. He also pushes back against the argument about Zoom, explaining that appearing remotely is an accommodation and that people can attend court in person. More importantly, the judge says the issue was not simply that Gubin was sick. In the judge's view, there were repeated opportunities to provide proper documentation, and the documents presented were not sufficient. This is where the case becomes more complicated. The defense is saying, essentially, look at the circumstances. The judge is saying, look at the conduct and the record. Neither side is really talking about the same thing anymore. And that difference in perspective is about to become even more important.
Mr. Gubin was given multiple times showing proper documentation. And we take it and we'll look at it on the screen. So he doesn't have to email it. He doesn't have to send it. He sends the first document. It wasn't valid. I said, Mr. Gubin, he indicated to the court that at first he indicated he got the truck, but he sold the truck. That was his first argument about what happened to the document. I said, do you have a truck? Do you have a valid document in your name now? He says, yes, I do. Then he emails the court the document, which I'll find in the record and put it in the file. He emails the court a document that shows me this deck sheet of insurance, but that insurance never had a date on it. So I addressed that with Mr. Gubin, and this is all in the record. And I asked him, hey, this doesn't have a date. Then he proceeds to show me another document that doesn't have his name on it, anything. And when we brought that up, and then that's when things went further downhill. So I don't think Mr. Gubin's actions had anything to do with him being sick that day. I don't know whether he was sick or not. And again, I don't care at this point whether he was sick or not. I tried to exercise every bit of restraint. Then he further argues with the court and tells me while he's swearing that the truck was stolen at gunpoint. That was his other argument. First he says he sold it, then he says it's stolen at gunpoint. Then Ms. Harris tried to step in and try to mediate the thing and calm the situation down. Mr. Gubin was not trying to hear that. And then Mr. Gubin goes all the way and puts race into the argument that it's because his complexion that I am the way I am, and I'm doing him the way he felt I was doing him, which was absolutely not the case. And I still was exercising restraint and not doing anything. He calls me uneducated. He starts to throw names and things like that. So that's why we're here. We're there. Then there's going to be a huge lawsuit. So that's why we're here. Furthermore, this happened in February of 2024, February 29th of 2024. Mr. Gubin had ample opportunity to come to the court and try and rectify or bring it in, Mr. Gubin knew the court imposed a contempt sanction on him before he left the court, and he never did. The only reason he's back in here now is because he got more tickets. I told him to show up in person multiple times before he hired you, Ms. Barkovich, and he disobeyed the court's order. So at this point, the only sanction that I think is gonna get to Mr. Gubin is a term of jail time.
The judge now explains why he believed Gubin was attempting to deceive the court. According to the judge, Gubin first provided documentation that was not valid. Then, another document allegedly did not contain the required date or Gubin's name. The judge says these issues were raised with him, but the situation continued to deteriorate. Then comes another major contradiction. The judge recalls Gubin first saying the truck had been sold and later saying that it had been stolen at gunpoint. From the judge's perspective, those statements looked inconsistent and contributed to his belief that the court was being misled. The confrontation then became even more personal. The judge says Gubin accused him of treating him differently because of his complexion and called him uneducated. So now the court is dealing with 3 separate issues: questionable documentation, conflicting explanations about the truck, and serious disrespect toward the judge. The judge ultimately says Gubin had opportunities to correct the situation and still failed to do so. For that reason, he believes jail is the only sanction that will get his attention.
May I respond to some of your commentary? I'm not here to quibble with you, but that was something I needed to discuss with Mr. Gubin once I actually became privy to the transcript, the inconsistencies with his representations to the court. I will tell you that I have received information that both statements he made to the court with respect to the vehicle were in fact allegedly true, in the sense that his vehicle was stolen. He apparently has a police report depicting that it in fact was stolen under the circumstances he represented. The vehicle was allegedly then recovered, returned to him, and then he subsequently sold it. So I can understand why the court thinks he attempted to perpetrate a fraud because he advanced seemingly inconsistent statements. But it is my understanding that he has documentation to back both of those points up. I'm not sure if that makes a difference to this court, but if it does, I'd ask for an opportunity to present that to the court. I understand my client made some statements which should not have been made, and he'll acknowledge that. I didn't advance his illness as an excuse, but I mean, we all know as human beings, any time we are not feeling well, we become more jumpy or, you know, less tolerable. So he apologizes sincerely. He has remedied all issues as it relates to his license. He actually has a valid driver's license at the present time. His car's insured, it's registered. I understand that you think a jail sentence is an appropriate sanction. If you are insistent on continuing to maintain that position, which you can do because you're the boss here, Judge, I'd ask that you consider a reduced sanction and give him a week.
But the defense attorney is not finished. He acknowledges that the statements about the vehicle sounded inconsistent, but offers an explanation. According to the information he received, the vehicle may actually have been stolen, recovered, returned to Gubin, and then later sold. If that documentation exists, the 2 statements may not necessarily contradict each other. That is a major point, because the judge's belief that Gubin was attempting fraud is partly based on how those statements appeared at the time. The attorney also acknowledges that Gubin said things he should not have said. But he argues that Gubin has since corrected the problems with his license, insurance, and registration, and is now legally compliant. Then he makes one final request. If the judge is determined to impose jail, reduce the sentence to 1 week. Now the court has heard both sides. The judge believes the defendant mocked the process and ignored repeated opportunities to comply. The defense believes the situation can be explained and that the punishment should reflect Gubin's circumstances and current compliance. Which argument is stronger to you?
I've heard the argument. Y'all let your client speak. If he chooses to, you don't have to if you don't want to.
You would like to, Judge?
I just want to start off with an apology. I apologize for my actions. They were totally uncalled for that day. And I made some terrible misjudgments, and I'm completely wrong for that on my part. And I don't want to try to defend anything I said that day because there's nothing to defend. I was completely wrong.
I can't. I just should have
All
died
right,
like last time I was on.
please, you gotta mute yourself. Go ahead.
I just believe that things were just misunderstood that day, and the documents that I was showing, it was misunderstood. And I lost my cool because I was very sick that day, and it's just a terrible mistake I made, and I regret it deeply. So,
Is that it, sir? This one document, Ms. Barkovich, that it was a deck sheet or part of a deck sheet that he sent me. It had pages 3 or 4. And this is the reason why I say intended to perpetrate a fraud. He could have sent this whole document. We all have insurance policies, and we know what those documents look like. And I have page 3 or 4 here. And I think he intentionally sent me these pages because he knew that if he sent me the pages that we were actually looking for, it would have had the proper data. Secondly, I wasn't misunderstood about anything, sir. I don't know why you were so misunderstood. I thought it was very clear in an effort of what we were trying to do for you. Whether you say it's sickness or anything, I take the uneducated comment as a racial trope. You know what I'm saying? I don't, you know, we've heard that in the tennis match the other day. The one of the players lost, and she calls the player uneducated. We hear this uneducated toward Black people, it seeming like more and more. So that's how I take that as well. So I don't think that I wasn't misunderstood about anything. You turned a simple misdemeanor, no insurance, no registration, or whatever it was, into all of this. And this is the consequence you're going to have to pay for. All right. I believe he was contemptuous. I believe he disrespected the court. I believe he basically was making a mockery of the whole situation. So I don't feel any, I feel you intended to do that, and I don't feel it became because you were sick. Okay? So that's it. I can give you the information that he gave the court on that day as a way, but everything he passed off to the court was either not valid at the time, or we would have given him time to get insurance. We do it constant.
I understand.
All right. So I'll consider the reduction, but I'm not. He's going to go to jail today.
I understand, Judge.
Finally, Gubin gets the opportunity to speak for himself, and his approach is very different from the earlier hearing. He begins with an apology and openly admits that his actions were wrong. He says his behavior was completely uncalled for and that he made terrible misjudgments. He also says he deeply regrets what happened. He explains that he was extremely sick and believes the documents were misunderstood, but he does not try to completely defend the things he said. The judge, however, remains skeptical. He returns to the insurance documentation and explains why he believes Gubin intentionally submitted incomplete pages. He also addresses the uneducated comment, saying he viewed it as a racial trope and did not believe the situation was simply a misunderstanding. The judge ultimately concludes that Gubin was contemptuous, disrespected the court, and made a mockery of the situation. In his view, the illness did not explain the behavior. Still, the judge says he will consider the request for a reduced sentence. This is a fascinating turning point. The defendant's apology does not erase what happened, but it may have given the judge a reason to reconsider the punishment. Do you think a sincere apology should influence a contempt sentence?
So you can, Ms. Barkovich, I'll pass the matter. You can go ahead about your day. You can zoom back in. I've heard your argument, and I'll make a decision before the day's out on if I'll reduce it.
Thank you, Judge. I appreciate the court's consideration.
All right.
Thank you.
All right. All right, let's pass that matter.
I'm sorry, Judge, did you say my name?
Yeah, I'm gonna go ahead and reduce it to 2 days for your client.
Thank you so much, Judge.
So like I said, it'll probably be out tomorrow. I don't know, but it wasn't. No, I appreciate your argument on behalf of him, but I don't believe it.
On the record,
No, this is, if I can put it on the record, when we get the file, I'll mark it down, but if not, then, we'll make sure 2 days gets entered, all right?
Thank you, Judge. He sincerely appreciates that.
I'm sure he does.
I do too. And thank you for your time today.
The final decision comes after the judge passes the matter and considers the defense attorney's request. The original punishment had been 30 days in Wayne County Jail, but the judge ultimately announces that he will reduce the sentence to 2 days. That is a significant reduction. The judge makes it clear that he still does not believe the record supports completely avoiding jail, but he accepts the argument for reducing the punishment. The attorney expresses his appreciation, and Gubin himself thanks the judge. So what can be taken from this case? The courtroom conflict began with a dispute over documentation and quickly escalated into accusations, insults, claims of unfair treatment, and contempt of court. The defense later presented mitigating circumstances, including illness, family responsibilities, and the defendant's lack of a substantial criminal history. The judge remained convinced that the earlier conduct was serious, but ultimately reduced the punishment from 30 days to 2. The broader lesson is not simply about who was right or wrong. It is about how quickly a disagreement can change once respect breaks down. A person may believe they are being treated unfairly, but turning that frustration into personal attacks can create consequences far beyond the original dispute. At the same time, the final reduction shows that courts can consider context, arguments from counsel, and later conduct without necessarily erasing accountability. So here's the question. If you were the judge, would you have reduced the sentence to 2 days? Or would you have kept the original 30-day punishment? If you found this courtroom breakdown interesting, make sure to like the video, share it with others, and subscribe to the channel for more courtroom cases, legal confrontations, and detailed breakdowns.